Good afternoon, everybody. And first of all, thank you for choosing to spend your lunchtime with me. For those that don't know me, my name's Jade Ferguson. I specialise in healthcare law. So mostly clinical negligence work, but I also do a lot of health and welfare work in the court of protection, particularly around care and treatment decisions. So today I'm going to be talking to you about capacity law, and in particular, capacity to litigate from a personal injury and clinical negligence perspective. Now, litigation capacity is something that crops up all the time in personal injury and clinical negligence cases. And I'm not just talking about multi-million pound brain injury cases, but also it comes up in smaller low value cases as well, where perhaps you have a suspicion that the claimant has some kind of cognitive impairment. That might be something that predates the accident, like a learning disability, or it might be the case that when you were first instructed, you had absolutely no concerns about the claimant's capacity. However, because of a condition, perhaps something like dementia, over time, that isn't quite as obvious, and you're having to question whether they still have capacity. So I find that when I raise the issue of litigation capacity with my solicitors, occasionally it's something that hasn't been thought about, but most of the time it's just simply that people don't really know what to do. And that's completely explainable by the fact that the CPR doesn't really help us very much. So we're all familiar with CPR Part 21, that deals with protected parties. And although that sets out a very helpful procedure on what to do when there is a protected party, neither the CPR or the practice directions set out anything on the procedure, on the process of determining whether somebody lacks capacity or not. So that's going to be the main focus of my talk today. I'm going to try and give you a practical guide in relation to litigation capacity and fill in some of those gaps that the CPR doesn't really help us with. So going back to basics, starting with the Mental Capacity Act 2005, the Mental Capacity Act sets out a definition for lack of capacity, and it's twofold really. So being unable to make a decision, and being unable to make that decision because of an impairment or disturbance in the functioning of the mind or brain. So to establish a lack of capacity, the Act requires two tests to be satisfied, and that's what I'm going to call the functional test and the diagnostic test. So starting firstly with the functional test, so whether someone's unable to make a decision for themselves. When we're looking at that, we need to be able to consider whether they're able to understand the relevant information. So that's the relevant information to that specific decision. If it was a consent to a medical procedure, it would be information about that specific procedure. In the case of litigation capacity, obviously we're looking at the specific ins and outs of the case. B, they have to be able to retain that information. They don't need to have a particularly long memory and be able to come back to this days and days later. They only need to be able to retain that information for a short period of time in order for them to be able to do the next step, which is use and weigh that information as part of the decision-making process. So C, as I say, weighing that information up, weighing the cons and the pros of any decision. And lastly, D, communicating their decision. That doesn't have to be by talking, it can be by sign language, it can be by any means of communication that your client uses. So just because somebody has difficulty communicating by speech, don't write that off as meaning that actually there's some difficulties here and those elements of the test might not be satisfied. Now, that's the functional test. The diagnostic test is in the Section 2 of the Mental Capacity Act, and it goes back to that impairment or disturbance in the functioning of the mind or brain. So we need to be able to establish that as a result of that impairment, someone is unable to make the decision. So there has to be a causal link there. Now, just going to talk through a quick example just to help us with that. So considering somebody that has schizophrenia, they're suffering a relapse and they're experiencing some delusions that someone's trying to poison them. They're asked to consent to a routine blood test just to check the liver because of the type of medication that they're on. The purpose of that blood test is explained to them, but this person insists that actually the nurse is attempting to poison them, and they don't really need to take blood at all. It's just a way of kind of getting to them with a needle. So in this example, the person has delusional beliefs which are preventing them from understanding the true meaning or the reason for the blood test. And it's also preventing them from being able to use and weigh that information appropriately. So the psychosis directly causes their inability to make the decision. So in this situation, it seems likely that this person might lack capacity for that specific decision. Now, let's change that scenario a little bit. It's still an individual with schizophrenia. They're still experiencing hallucinations, but they're on medication and they're otherwise stable. They're also asked to consent to a routine blood test. They're able to repeat back why they're having the blood test, that they understand that they need the blood test to check their liver function. They might be able to weigh up the pros and cons of that decision. But ultimately they say, I know that this is actually a really important blood test, but I'm scared of needles and I'd rather not have it today. So although this person has an impairment, they have the schizophrenia, that impairment is not directly causing their inability to understand, retain, weigh, communicate. Their refusal is actually based on doing all those things, weighing up the considerations and just deciding actually my fear of needles is getting in the way of this. So it looks like this is a capacious decision, even if you and I might consider it to be an unwise one. And the Act is very clear, and we'll come on to this, that just because somebody makes an unwise decision doesn't mean that they necessarily lack capacity. Just finally on the functional test, so Macpherson, it was recently confirmed in the Court of Appeal that the functional test should be applied first prior to the diagnostic test. So this is just a helpful practice point, especially when you're considering capacity yourself, but also when instructing experts. So I think it's something that is probably likely to need to be included within your instructions to your experts. So when you're setting out the legal test, also perhaps a reminder to do it that way around, just so you don't come into some difficulties later on. So what other principles, general principles, do we need to keep in mind that are within the Mental Capacity Act? It's, first of all, presumption of capacity. We must always start from the position that a person has capacity, unless it's established otherwise. So capacity isn't something that needs to be proven, it's assumed. Number two, support to make decisions. A person shouldn't be treated as being unable to make a decision unless all practicable steps have been taken to support them, and those steps have not been successful. So this might include very simple things such as using plain language, breaking things down into smaller parts, offering written advice rather than verbal explanations, choosing a calm environment, and kind of timing the discussion for when someone is feeling less anxious or perhaps they're in less pain. So it is taking all practicable steps to help somebody to make that decision. The next point is one that we've covered a bit, which is unwise decisions do not equal incapacity. People are entitled to make decisions that other people think are poor or risky or simply unwise. And the space between an unwise decision and there is a space between an unwise decision and one that someone doesn't have capacity to make. So again, something to keep in mind, even if your client is wanting to accept a particularly low settlement offer, it might be incredibly unwise, but it doesn't necessarily mean that they don't have capacity. And lastly, capacity is decision specific. So capacity isn't global. A person may have capacity for some decisions, but not other decisions. So, for example, somebody may lack capacity to manage their finances, but they would have capacity to litigate. So each decision needs to be assessed separately. So moving on to what exactly is litigation capacity? Because as I've just set out, capacity is decision specific. So it's really crucial to understand what exactly we're talking about here. Now, the test originally comes from a case called Masterman and Lister. That case actually predates the Mental Capacity Act, but it is consistent with it. So the core question really is whether a party to legal proceedings is capable of understanding, with the assistance of proper explanation from legal advisors, issues which they likely need to make decisions on during proceedings. So there's a few elements to that, but the one that I would like to draw your attention to is this part where it says proper explanation from legal advisors. As we all know, clients sometimes struggle to grasp legal concepts. It doesn't necessarily tie into them not having litigation capacity. When we're talking about what understanding clients are expected to have. But we're not thinking of kind of giving them the CPR to read on their own. And if they don't get the basics, then they probably don't have a good understanding of it. We're looking at somebody who, if they were given a good legal explanation by professionals of the case and the matters they need to understand, they would be able to grasp it. Now, that case was refined over the years by quite a few cases, but some of the ones that are most important is the case of TB, where 2 points were emphasised by the court. That's firstly that capacity relates to the specific litigation. We're not talking about someone's general ability to grasp kind of broader affairs or legal concepts in general. The assessment must focus on that particular claim. So, for example, in a personal injury claim, they would need to understand the events giving rise to the claim, the key issues of liability, the concept of quantum and how that's calculated, perhaps issues around fundamental dishonesty and any cost consequences. So the test here is targeted and claim specific. The second really helpful point from this case is that it's just a reminder, really, that litigation is a dynamic and transactional process. It involves recalling all sorts of information, giving instructions kind of on the spot, receiving legal advice, written and verbal, and making decisions repeatedly as the case develops. So what that means is that although the scope of what needs to be understood is focused on the particular litigation, the depth of understanding required is perhaps quite significant. And there needs to be a certain level of mental agility by your client to be able to process that information over time. So again, it's just something to keep in mind that at the start of litigation, it might appear that your claimant does have litigation capacity, but perhaps as things become more complex, it might occur to you that actually this might not, that they might not have capacity. Now, the case of Re P, the court was quite direct in this case about the realities of litigation, and said that even simple litigation can be legally and procedurally quite complex. And it confirmed that the threshold for litigation capacity is relatively high. So again, when it comes back to understanding, taking everything into account, I think it's important to keep in mind that it is a relatively high threshold. It requires not in-depth understanding, but perhaps a deeper understanding than superficial legal complexes, and how that applies to that individual case. Now, you've probably sat there thinking, well, what's my duty? What do I have to do in relation to litigation in litigation capacity? And I'm afraid to be the bearer of bad news, but it is for you as a legal representative to decide whether your client has capacity to instruct you. You must satisfy yourself about their capacity. It isn't something that can really be delegated. And frankly, you want to try and get to the bottom of that as soon as possible if you have any doubts, just to avoid any difficulties with the SRA. So if you have a reasonable doubt about your client's capacity, you are under a professional duty to investigate that issue. And that means taking steps yourself to inquire, or maybe that's seeking medical evidence or obtaining a specialist assessment, or it could be speaking to family members and going to speak to the claimant in person yourself. Now, recently, in a couple of my own cases, I've had instructions from solicitors where they haven't actually spoken to the claimant themselves in quite a long period of time, just because another family member has been delegated to deal with kind of the day-to-day running of the case. To me, that screams out red flag. If you've not spoken to your claimant for perhaps over a year and it's the claimant's daughter or partner that you've been dealing with, you need to check whether that person is delegating because they don't understand and perhaps they don't have capacity, or whether they would just rather do it that way. So it isn't always the case that if you get a claimant that doesn't want to deal with you directly, there's a lack of capacity there, but it's certainly something that I think is missed if you are dealing with a family member over a long period of time. The other point I should raise at this point is that the evidence supporting, if there is evidence supporting lack of capacity, and there's no disagreement between the claimant and you that perhaps they don't have capacity, the general position is that the defendant should not be permitted to challenge the appointment of a litigation friend. So in other words, the question of whether a party has litigation capacity isn't an inter-parties issue. It is fundamentally an issue between you and your client and the court. So there are circumstances where capacity does become a relevant issue to proceedings. For example, where the claim includes a claim for court of protection costs. The defendant in those circumstances may have a legitimate and proper basis to challenge the claimant's capacity. But ordinarily in kind of low value cases where this kind of thing doesn't have any bearing on the issues of the claim itself, it's not something that the defendant is entitled to be involved in. Now, turning to assessing capacity. Medical evidence is often preferred, particularly by the court, but it's not always necessary. When determining capacity, the court has to consider the functional and the diagnostic test that I've set out. Because it has that diagnostic element in it, it's quite common to see generally some medical evidence to support that, particularly in relation to the impairment of the mind. However, it is not necessary, nor is it always practical. And sometimes a party might not want to engage in an expert assessment on capacity. Perhaps there's no funding, no way of recovering the costs of a capacity assessment. So in many cases, litigation capacity is not a substantive issue in the claim, and it's just purely about trying to protect the claimant. So if from your own observations, you believe that the claimant doesn't have capacity, you have information from family members, carers, or the professionals involved that indicate actually this person doesn't have capacity, it might be reasonable and proportionate to not seek any additional medical evidence, but to rely on kind of the statements from people that you already have, and the medical records that you already have hold of. Another kind of route to exploring capacity without seeking an expert report would be to seek some records from the local authority, any social care records. You'll find that quite often, particularly if you've got a claimant that's in a care home, the local authority social services will have carried out some kind of capacity assessment of their own. So if you request that, you should be able to receive a copy, and that might save you going down your own route of expert evidence. But I say that and keep in mind my earlier point that capacity is domain specific. So if the local authority have done specific capacity assessments in relation to consent to medical treatment, but haven't considered capacity on a more broad level, it gives you a bit of help as to whether this person has capacity to litigate, but ultimately you will need to do a bit more digging around rather than just relying on that other capacity assessment, which is on a different area and will have considered different information. So ultimately, in the context of litigation, it's the court that decides whether a party has or lacks capacity. But you'll find that if you've appointed a litigation friend, you're fairly certain on the lack of capacity. It's usually something that the court wouldn't necessarily get involved in, and you'll find that you're at an approval hearing, and although the judge may ask some questions about it, you don't need to point towards kind of hard expert evidence, as long as you have some evidence to point to lack of capacity. You do have a professional duty to ensure that the court is aware whenever capacity is in doubt. And I refer you to the Equal Treatment Bench book. I think I might have included it in some of the links at the end, but that provides some useful kind of framework for judges on assessing parties' capacity to participate in proceedings. So again, it might be something that you want to have a look at and can apply to your own practice as well. Now, expert evidence, and when this is required, you'll find that in some cases, perhaps it is very, very straightforward. Let's take an elderly claimant that's in a care home. She's had dementia, dementia diagnosis for over 5 years. Professionals, you and the family all seem to agree that actually she lacks capacity to litigate. That's quite straightforward. Doesn't need the expert evidence that we're going to be talking about now. It becomes more complex where capacity isn't obvious, perhaps where it's relevant to proceedings if there is a claim for deputyship costs or quarter protection costs, and there's also circumstances where perhaps the claimants themselves say, hang on a second, I dispute this, I do have capacity to litigate, and they don't want to kind of let go of that power. So in these situations, it is important that you obtain expert evidence that assesses that capacity on an issue-by-issue basis. The most appropriate experts are usually psychiatrists or neuropsychiatrists. The kind of next step in discussing this with the client is setting out your concerns in relation to capacity. So even if you think expert evidence is necessary, the claimant has to confirm that they're happy to have that assessment. It can't be done covertly. They need to know what's going on. So before you commission any evidence, you need to speak to your client. It might feel obvious, but you need to discuss the purpose of the capacity assessment, outline if they're found to lack capacity, what that means, what that will mean going forward, and ensure, as I say, that the client consents to this process. When you come to instruct your expert, it's so important to make sure that your expert is fully informed of all of the relevant issues. So you'll find that some experts won't kind of comment on capacity unless they are specifically asked to, and they might not talk about specific domains of capacity. They might talk about it generally. So if you are concerned about litigation capacity, you need to set out in no uncertain terms to your expert that that is the question that you need them to answer. You need to provide them with up-to-date medical records, kind of GP, CPN records, DWP records, anything you can get from the care home and support workers, just to make sure that they've got a full and holistic view of the claimant before meeting them for an assessment. It's also important to set out specifically what your concerns are. So let's say that you don't have any doubt that your claimant understands liability, but quantum is quite complex, and you're concerned that they won't be able to, they don't fully understand that, and won't be able to make capacious decisions about that. That is vital information to pass on to your expert to make sure that they consider those points in detail. Now, you should always as well ask your expert to explain how the client's condition might affect their ability to make a specific decision. And again, it's going back to the functional and the diagnostic test, making sure that none of that is skipped. So we need that causal link. And the bit that experts often struggle with is ensuring that that causal link is met, that it's the impairment that is causing an inability to make a decision, not that actually this is just an unwise decision that they disagree with. So I was trying to hammer home that you need to chat to your claimants about this and make sure they are fully informed about capacity assessments and why you want to go ahead with this. But what if your client says, I don't want to have a capacity assessment, which might be the case, especially if they're worried about the outcome of that, and what that might mean to their kind of loss of control over the case. So if you do get a client that refuses capacity assessment, you need to take reasonable steps to encourage them to engage with an assessment. If they refuse, then you must decide whether you can reasonably, in your own opinion of their capacity, go ahead with the case. So if you have serious concerns about capacity, even if they're refusing an assessment, you can't turn a blind eye to it. You have to really sit down and think about whether actually we need expert evidence on this point for me to continue to act. The risks of not kind of going down that route and pressing on anyway, as I said earlier, will probably get you into trouble with the SRA, or potentially lead to a problem later on down the line if something's undersettled, leaves you open to further litigation. So if proceedings are contemplated or ongoing and capacity is still in question, you can apply to the court for a determination. The court may order an assessment. Again, the claimant might disagree and not go along with that. But push comes to shove, the courts can make a capacity decision for you. It's quite a lengthy process and not something that I would want to urge you to jump into. But if there's no way of talking your claimant into getting that capacity assessment and you think you need a final decision by the court, then it's better than perhaps leaving them without representation. Now, there's a case that it's called Hinduja. I've not put it on the board, but essentially it says that medical evidence isn't a formal requirement for a decision on capacity, but in practice, judges are reluctant to make significant decisions about capacity without expert support, especially where it's a question of the evidence being finely balanced. So the judges will do what they can with that, but you might find that they seek a capacity assessment, a court-ordered capacity assessment, where although there's not an in-person meeting with the claimant to help the expert is still asked to determine the issue based on the medical records, what information they have from you or from family members. Now, litigation capacity versus financial capacity, I just wanted to make the point that these two are distinct. It's vital to remember that capacity is domain specific, and someone can have litigation capacity and not financial capacity. So where a claimant does not have financial capacity and the claim is substantial, you should be considering a claim for a court of protection, deputyship costs. You probably will need expert evidence in relation to that. This is usually a route where the defendant is justified in challenging capacity. So the simple fact that a significant amount of money is likely to be awarded, it usually is enough to trigger the need for court of protection involvement. So it is something to keep in mind. I could do a whole talk on that separately, but I just wanted to draw the distinction between the litigation capacity and financial capacity. There's often a little bit of overlap, but you do need to be looking at those two issues separately. Now, settlement. We'll have all read over CPR 21, and the position is really clear that where there's a child or a protected party, you need the approval of court for any settlement sum. The bit that sometimes is missed is, and I've put it in bold, is the voluntary interim payments. Just stressing that because I've had on a couple of occasions where solicitors haven't realised that actually they require approval of the court as well. So just to emphasise that. The other point I wanted to make in relation to settlement is even if you have some doubts about capacity, what you can do is apply to the court for an approval hearing. So even where, let's say your client has capacity or you think they have capacity all the way through proceedings, you've come to settlement, and perhaps something happens, there's been some deterioration where you're concerned that they no longer have capacity. If that occurs, it would be potentially a longer process of going down the route of obtaining expert evidence and things like that. A shortcut potentially is in the case of Coles and Perfect. So in Coles, neither the claimant or defendant asserted that the claimant lacked capacity. both accepted that it was finely balanced, but to protect the claimant and for the solicitors to protect themselves as well, they applied for court approval of the settlement. Now, in Coles, the judge found that it has an inherent jurisdiction to approve a settlement without first determining capacity. So you can apply for an approval hearing and get the judge to look over the settlement sum without them having to dive into the complications of litigation capacity. And then if they do turn out to not have litigation capacity, you've covered your back and the court has properly approved the settlement sum. If later on down the line it turns out actually your client did have litigation capacity all along, well, no harm has been done in having the judge look over that settlement. The defendant might try and challenge the costs of that, but ultimately, if capacity is finely balanced, and actually it might save time and costs in the long run, I assume that most of the time they'll likely agree to an approval hearing. So to bring everything together, capacity is always decision specific. It always needs to be evidence-based. It doesn't necessarily have to be from an expert, but there needs to be some kind of medical records, family statements, statement from yourself, where all that evidence has been considered. And lastly, it is always your responsibility to consider litigation capacity. So if you're unsure, ask. If you have any concerns, just investigate it anyway. And if the issue arises late in the day and you're concerned about it causing any delays, the case of perfect is a good one to fall back on. So if capacity issues are handled correctly, there's no reason for it to cause any friction. It just simply ensures that the right safeguards are in place for your client and I guess for you as well. Now, I've included on the last slide my email address. If you have any questions arising out of what we've discussed today, or you've got any specific issues in your cases that you want help in hand with, please feel free to email me. I've included a couple of useful links on there as well. One's to a report carried out, a judiciary report, which it talks mostly about the issues with CPR 21 and as well tries to fill in the gaps as I've done. And there's also some useful guidance from the Law Society on how to work with clients who may lack mental capacity. So that's everything from me. That was a whistle-stop tour. If anybody wants to ask any questions, I'll hang around for a few minutes, but if not, I'll let you get on with your lunchtime.